Hello, everyone. Welcome to Legal Funding Journal's virtual town hall, Patents and Trade Secrets. I'm your host, John Freund, managing editor of Legal Funding Journal. I want to thank you for joining us today. We've assembled a terrific panel around what is a very timely topic. We got a lot to cover today, so I'm just going to make this very quick. So first off, all registrants will receive a link to a recording of this event. Please stay tuned for that via email post-event. The format of today's event, it's going to include a panel discussion followed by a Q&A with you, the attendees. So we would really love for you to participate. And there's two ways for you to do that. You can submit questions via the comments feature right there on LinkedIn. I'll be monitoring that throughout the event. Or you can also email your questions to john@legalfundingjournal.com. That's JOHN at legalfundingjournal.com. I'll be monitoring both of those throughout the event. And we're going to get to as many questions as we can at the very end of the event. So we encourage you to submit your questions throughout the event. Also, we will be hosting virtual town halls on a monthly basis, and we'll be addressing themes and topics that are important to our community. So we also encourage you to submit those topics, suggest anything you'd like, and to also attend those events in the future as they arise. Lastly, Legal Funding Journal is the most comprehensive source of news and events taking place in the legal funding sector. Our members rely on LFJ to stay on top of case developments, funding activities, regulatory updates, people moves, and also to gain access to original content that's produced by some of the leading thought leaders in the industry. If you'd like more details on becoming a Legal Funding Journal member, you can visit us at www.legalfundingjournal.com. With that, I'm going to turn it over to today's moderator, Salumeh Loesch. Salumeh was a patent litigator at Klarquist Sparkman for over 15 years before she started her patent monetization business. At Loesch Patents, Salumeh helps patent owners ranging from solo inventors to large universities and corporations monetize their portfolios by developing a litigation and licensing campaign and obtaining litigation funding to support the monetization efforts. Salumeh, take it away, please.
Well, thank you so much, John, and thank you, everybody, for attending. We have a great panel. I'm going to do some brief introductions of our panelists before we start. First, we have Robin Davis. Robin is a director in the Intellectual Property Finance Group at Fortress, where she's responsible for the growing portfolio of litigation funding investments in IP litigation. Fortress's IP group specializes in providing capital solutions to patent owners, including through private equity, credit, and litigation funding investments. Prior to transitioning to the litigation finance world, Robin spent 10 years as a patent litigator, including at Quinn Emanuel and as a partner at Radulescu. But I misspelled. I mispronounced that completely.
Radulescu, close enough.
Radulescu. Robin also spent 5 years at Woodsford Group, a London-based litigation funder. She served as the chief investment officer responsible for Woodsford's U.S. patent portfolio and a member of their board of directors. We also have with us Scott Davis, who I used to work with. He's a partner at Klarquist based in Portland, Oregon. He has 25 years of experience and focuses on intellectual property litigation, representing clients in courts throughout the U.S. He's had success both obtaining relief for IP owners and defending suits in a wide range of technical fields in cases involving patents, trade secrets, unfair competition, employment agreements, copyright, DMCA, trademark, trade dress, product configuration, and false advertising claims. He also represents clients in post-grant proceedings at the USPTO. Also as outside counsel is Erick Robinson. He is a partner at Brown Rudnick and co-chair of the firm's PTAB practice and is a leading patent litigator and trial lawyer focusing on bet the company patent cases on behalf of both plaintiffs and defendants, representing clients ranging from Fortune 100 companies to solo inventors. Erick has managed and tried patent cases in the U.S. and around the world, including multi-jurisdictional cases in China, Germany, France, Brazil, Vietnam, and Singapore. Pretty impressive. He was based in both India and China and remains an expert in international patent law. Erick has spent over 20 years working in top U.S. IP law firms, and he previously served as a director of patents for Qualcomm and as senior patent counsel at Red Hat, and as director of patent litigation at a top Chinese law firm. And finally with us is Anup Misra. Anup is the managing director of IP at Curium Capital. Curium is a general commercial litigation funder with over $1 billion in assets under management. Anup leads Curium's patent and IP litigation investment efforts. Prior to joining Curium, Anup was a patent litigator for 10 years at several large international firms, primarily representing large tech and telecommunications companies. So with this great panel, we're going to tackle the subject of litigation, funding, and trade secret and patent infringement cases. And we're just going to start off with talking about trade secrets a little bit and the difficulties potentially in proving up damages in trade secret cases. So what should plaintiffs do to best position their cases for funding if they have a trade secret dispute? Anup or Erick, do you have any thoughts on that?
Yeah, I can start in on that, Salumeh. So I think to position yourself for a trade secret dispute, I think it's really important that when you come to a funder, you've really like sort of granularized what the trade secret is. You know, how are you going to present the trade secret or trade secrets as it may be? What are the sources of proofs that you already have? And like, what do you expect to get in discovery? What do you need in discovery, and how are you going to get it? Because trade secrets are a lot more nebulous than patents are, right? And so to sort of prove them is just a lot of different factors. It's very jurisdictionally, the jurisdictions are going to be very different on how they require you to prove your trade secrets, how they require you to define your trade secrets. So I think having all of that buttoned up before you come to a funder is going to increase your chances of getting funding for that trade secret case significantly.
But trade secrets have become more popular. It's like for plaintiffs to assert, for companies to protect. Erick, do you have any tips for how companies can protect their trade secrets but still potentially obtain funding in the litigation?
So I think, first of all, I think my first advice to companies is to have a trade secret management system. You know, that can be as complicated as having an entire software suite. That can be as simple as having a spreadsheet that has trade secret, date, who came up with it, and additional details. And that actually feeds into the real answer, which is you need to know what the trade secret is. Once you know what the trade secret is, things get easier. Now, that's hard. That's easier said than done. And I've been in cases on both the plaintiff and defense side where nobody really knew what the trade secret was until trial, which is what makes it crazy. But damages, the good news is that it's a lot more flexible than damages, for instance, in the patent world. Like, you can get actual losses, you can get an unjust enrichment. Of course, you can get reasonable royalty, like patents. You can get punitive damages. You can, there's just a lot broader system damages. And so my advice is, you're going to have to do a lot, maybe even more work on the front end. I think patents are more complicated from a technical aspect and understanding validity and things like that. But trade secrets are much more factual because there actually has to be a bad guy. Unlike patents, where there can be innocent infringement, trade secrets, somebody has to have stolen it. And that story also impacts damages, because if somebody really stole stuff after an NDA, juries don't like that.
Yeah, if I could add one point to the damages part, I think Erick makes some good points there. For patent damages, most funders have in-house IP experts that, can understand how patent damages would look, or have a good instincts on that, at least about the range of damages in a patent case that you're presenting. So it's not as important to have like an expert, patent damages or IP damages expert weigh in before you get funding. Now, some funders still require that, but not all do. I think for trade secrets, it actually is very important to have an expert weigh in on your damages when you're seeking funding. As Erick described, the damages are going to be a lot more nebulous. They're not as clear cut. And having somebody with real experience in proving trade secret damages that's won sort of large trade secret damages verdicts in the past, or, contributed to large settlements, can be extremely beneficial in getting your case across the line with a funder.
And so, Anup, do you feel like, in the litigation world, generally, like there's a greater interest in trade secret enforcement and litigation just because of the difficulties with patent enforcement. Do you feel like there's a growing interest from the funder's perspective to fund trade secret cases, or does the hurdle in the damages analysis kind of prevent that interest?
I think there is a greater interest in funding trade secrets across the industry. I think every funder is going to be a little bit different on how interested they are in trade secrets litigation. Just to be perfectly candid, for example, Curium has not typically been as interested, just because I think collectively in our practices and in funding, we haven't had the best experiences with trade secret cases, right? Other funders, though, probably love trade secret cases. Now, that's not to say we won't do them, and we certainly see more of them. And we're certainly seeing a lot more sort of combo trade secret patent litigation, which I think is extremely interesting for funders. And if you can sort of manage that, it really puts your case sort of on the upper shelf of what funders are going to consider.
To add on to that, I've seen, I think Anup is absolutely right, and that's exactly what I've seen. I will say that if you have a single trade secret case, you may have a much harder time getting that funded than a single patent case. But if you have a trade secret case or two that you can add to a portfolio of patent cases, that actually is a win-win and can help the likelihood of getting both the trade secret and the patent cases funded.
And I'd just add really quickly that to follow on what Anup said about having a combination of theories in a case with a patent and trade secret. I don't recall the last time, if ever, I've litigated a pure trade secret case. There's always other issues in play. Usually for me, it's like employment agreements, a breach of contract, a relationship gone bad, so other claims around that. And ideally, a strong case combines, in my view, patent and trade secret claims. And, I hopefully that will help, with funding and any issues with damages and understanding that. But I think putting it all together, not just as far as the damages case goes, but what is your trial theme? What's your story? And the trade secrets on top of patents and the mix can be very compelling.
Yeah, no, I think that's right. And the key, I think, is, delving deep so that you understand the morass that Scott just described. I've seen in addition, like divorce cases thrown in for good measure. Then you add the fact that now it's both state and federal trade secret law. And, so you need to figure it out, but then you need to bring it back and make it clean because, Anup and the diligence people, aren't going to take, 30 pages and figure it out for you. You really need to break it down cleanly. And then they'll ask questions. And I know personally that Anup asked really good questions, challenging questions, but good questions.
Yeah, and I think I'm sorry, go ahead, Salumeh.
No, go ahead.
Well, I think, I think you guys all raise interesting points. Trade secret claims are, I think, probably very interesting and often arise in a more complex situation. And so if you want to make, the likelihood of funding most successful for those cases, I found that the best presentation that's done the homework kind of that Erick was describing, right? Figure out what exactly is your trade secret. What were the confidentiality obligations surrounding that trade secret that were violated? Who violated them? Who misused them, and how did they misuse them, and what harm did that lead to, which comes into your damages theory. I think that sometimes trade secret cases are inherently coming out of a looser situation factually, but to tie it back to kind of those key elements one needs to prove makes it easier for funders and is kind of the analog of preparing an infringement claim chart that most funders would look for when they're considering whether to fund a patent infringement case.
One more aspect that I'd chime in with is that when you have the combination of trade secrets and U.S. patents in a case, you have the ability to pull into a single U.S. litigation where you're entitled to a jury the potentially global touching conduct, because the trade secret law, especially under the DTSA, as I've applied it in my practice, can be quite far-reaching, crossing borders, and it otherwise would be quite difficult or impossible in many cases to get international type sales type damages into a pure patent case whereas trade secret can sort of move the needle to potentially get you a broader set of damages and relief on more of a global scale in a single case, which ought to give it more leverage if you play that right.
That's a great point. I will also add that, discovery isn't exactly exciting, and I think all of us on this call would agree with that. But in the current world, most courts aren't a fan, and honestly, I'm not a fan of receiving detailed email discovery in patent cases because the ROI is just not there. But, for trade secret cases, you have a much wider berth of availability of discovery, especially if you got some state court stuff going on. And again, I always think from the plaintiff side, although I do represent defendants if I have to, and it can, it's sort of like being the petitioner at the ITC. I think the plaintiff in a trade secret case has a tremendous advantage, not the least of which is they know it's coming. And like I said, it takes a long time sometimes for even, the plaintiff to know what the trade secret is, and for the defendant that can take months or possibly even years. But I love the idea of the damages. That's brilliant because in patents you can get sometimes extraterritorial damages, but it's basically provided for under federal trade secret law.
Well, that kind of is a good dovetail to our next topic, which is cross-border patent litigation, using international courts to conduct a campaign. So we understand in trade secret world, it's a lot easier to do that. And I just wanted to get some of your thoughts on how you should consider that approach in the patent context, and how this applies when you're seeking funding. Robin or Anup, if you have any thoughts on this.
Sure. Obviously, if you have patents in multiple jurisdictions, the US, Europe, beyond, that is a real asset, and obviously something you should be bringing to the attention of a litigation funder if you're seeking investment in your case. The key is really going to be to make sure that whatever international strategy you're considering is one that takes advantage of the various strengths and differences between different forums around the world. For instance, many people have always enjoyed filing in the US because there's potential for large damages awards. However, US district court litigation, especially with the advent of stays for IPRs, can be slow depending on where you're litigating. There are faster forms in other parts of the world. For example, Germany has long been considered a favorite in that regard. And with the advent of the UPC, the Unified Patent Court, which is now in many of the EU member states, this gives you both a faster timeline to a resolution, the possibility of an injunction, and it's a much bigger market now that you've got multiple EU member states, different countries in Europe that are all able to be adjudicated in a single proceeding. So that the UPC has, I think, created a lot of interesting opportunities. And so if someone is a patent owner who's looking for litigation funding to a multi-jurisdictional strategy, I think that's a total asset. And it's fabulous if you have counsel that you're working with who are able to kind of consider and advise on how to work together those multiple jurisdictional strategies. And there's certainly funding options and sophisticated funders excited to work across multiple jurisdictions simultaneously.
Yeah, just to add to a little bit what Robin said, I agree with all of that. I think the UPC has been sort of a fantastic development for patent owners if you have sort of European assets that you can assert. I think what I would add is that, this is really directed toward U.S. counsel. And I think Robin would agree with this. The vast majority of funding opportunities come to us via U.S. counsel for U.S.-centric cases. To date, when we have done sort of cross-border campaigns, it's almost felt like I've been the driver of that. I've seen that, hey, these people have a European asset. Let's go find European counsel and assert this in the UPC and see if we can add some additional pressure onto the defendants to settle this for the reasons that Robin mentioned: injunctive relief, pretty big market these days. It's still to be seen how damages are going to work, but the injunctive relief is a huge driver. But I think U.S. Litigation Counsel is still very focused, for obvious reasons, on the U.S. portion of litigation. I think a way for counsel to really separate themselves and their cases from a funder's perspective is to have looked at the foreign patents in your client's portfolio, come to the funder with a foreign strategy, have a couple law firms that you think would be a good fit with the understanding that, listen, you're still going to be the driver of this case. The European counsel or the Indian counsel or the Brazilian counsel, whoever else you need to use, we'll treat those as an expense, basically. They basically work for the U.S. counsel in a lot of ways. And then let's kind of file all of those simultaneously. All of a sudden, the length of time in the U.S., all the negatives that you can have in the U.S., if there's a 101 issue, the PTAB, the likelihood of a stay, the fact that we have a federal circuit that is, fairly defense heavy, in my opinion, at least, you've sort of negated all of that, or at least neutralized all of that. And so I think, that is my advice to sort of counsel and, other entities that have multiple patents that in foreign countries. Come to the U.S. funder with all of that sort of ready to go. I guarantee you will get a lot more interest for your case than if you just have, sort of the typical, let's file in West Texas, we've got 2 years to trial, et cetera, type of case.
Yeah, no, I think that's absolutely right. And, I think it's interesting that a lot of U.S. counsel have, it doesn't seem strange to them to think, well, we might want to add an ITC case, to leverage, some speed and some injunctions, but they're scared or just don't even think about, adding Europe, or Brazil, where you can get, preliminary injunctions fairly quickly, in some cases. The world's gotten a lot smaller, notwithstanding the last month or so. And, you got to use all the resources you have. For Qualcomm, I was in India and China, and I actually worked for a Chinese law firm. I think that there are some problems with the Chinese system that didn't exist when I was there, but you really got to take, number one, if they don't have foreign patents, then sorry, you can't play. But if they do, New's absolutely right. Robin is absolutely right. You got to analyze those. And, what I have seen, and again, this is, I've worked with foreign counsel that are far smarter than I am, which is not that high a bar. But what I will say is that I'm a better manager of the process. Some of the German counsel I've worked with are just amazing. But, in terms of being a master of ceremonies, you got to check your ego at the door. If the best thing you have going for you is a German asset, then freaking use it. And the other thing I'll add is that, as we talked about, and as Scott pointed out, that it is much harder to get extraterritorial damages in U.S. patent cases than it is, for instance, a trade secret. But it is not impossible, and in fact, it's easier. There's been follow-ons from the Western Gecko case that, Western Gecko was specifically, many people thought it might be limited to lost profits, which are really hard and rare to obtain in patent cases, unless there's direct competitors. There's been follow-ons that I wouldn't say make it clear, but certainly show that you can get reasonable royalties in certain situations, and a lot of practitioners don't even go down that road. I just had an associate who's a brilliant guy, come up to me and like, what about foreign damages? And I was like, that's why we have smart people. Because, and again, I preach about this, but it's all about the ground level work. So it is, I still think damages in the U.S. are better than any place else. Validity is, which is, put it mildly, kind of screwed up. Nobody knows what 101 means. The Federal Circuit thinks it means 103. Luckily, the PTAB can't adjudicate 101, but sometimes even they basically do by confusing 103. If you have patents from different strategic areas, you absolutely should use it. And I think one of the things that we're going to see in the coming years is the ASEAN area of the world become more and more important, because Vietnam, Indonesia, and several other countries in the region are becoming the new China for manufacturing. And if you can get an injunction where there's manufacturing, that becomes a worldwide injunction real quick.
Well, so to kind of, you were speaking about the issues in the U.S., whether it's 101 or PTAB. It looks like there might be some changes to the PTAB rules to potentially have more discretionary denials. And I wanted to get, your thoughts on the impact of that, both in terms of the changes to the types of cases that may be brought, potentially a rise in patent litigation and patent litigation funding. So if anyone has any thoughts on that, Anup, Scott, if you have any thoughts on how the current landscape is changing potentially to make patent litigation a little different in the coming year or two.
Yeah, I can speak to that as far as the changes at the board and the patent office. Discretionary denials are increasing. Just in our own practice, we've seen a dramatic change very quickly on that, and I think that's going to continue probably as a trend for some time, at least until folks filing petitions figure it out as far as what the rules are and as far as what the standards are and what factors are weighed most heavily in the analysis in order to basically present the best argument they can to keep their petition on track. But I think certainly in the short term, discretionary denial is a real thing, and it's surging. So there's an opportunity, I guess, to take advantage of that potentially while the rules shake out and both litigants and the board are trying to adapt and adjust to the new reality. But I will say one thing that seems pretty clear is if there is any overlap of issues that would potentially be litigated in the IPR and in court. For example, it's long been the case that a Sotera stipulation, a stipulation not to raise any arguments or art that reasonably could have been raised in the IPR proceeding in court would used to be almost sufficient to avoid discretionary denial. But now the board seems to be taking a deeper look. And if there's any overlap in the issues, so for example, if there's a printed publication, prior art that's relied on in an IPR petition, but in the petitioner's back pocket, they've got the notion in the district court of possibly relying on an underlying system that the applicant for the paper art had developed or something like that. That overlap of issues is probably going to be fatal going forward for IPRs, but something that a broader stipulation could potentially overcome. So I think that right now we're in the period of adjusting to what the new rule is, and maybe the rule will change. Given these times, we've seen lots of shifts and change that make things a little bit unpredictable and uncertain. But I think the uncertainty at present works in favor of patent owners and against petitioners and IPRs.
Yeah, Salumeh, just to add a quick point to that, sorry. I am cautiously optimistic about the changes in the PTAB, but from a funding perspective, I don't know that it changes anything for us. We're never funding a case with the thought that we'll get a discretionary denial on the IPR. So if we don't believe that we would outright win the IPR, whether it was an institution denial on the merits or even potentially winning on a final written decision if it came to that, we're probably not going to fund a case that has some validity, probably is problematic on a validity front, but we think we can get past because there's going to be a fintive denial. So I don't know that it changes a lot from a, will your case get funded perspective. I do think that the potential for, helping patent owners actually monetize their litigation will go up from this. So, on that area, I agree that I think this has all been a positive development for patent owners. But I don't necessarily think it's going to increase sort of funder appetite for cases that they wouldn't have funded before.
Just to echo that, I agree with Anup. I don't think that the standard of quality in terms of the assessment of the strength of the validity merits of a patent that a funder would apply before they agree to fund a litigation that is going to change in result of this. But what I think might help, just speaking very broadly, is many times in passive litigation funding, the funding terms, the money gets more expensive the longer it's out the door, right? Mm-hmm. That tends to be the case across many different investment classes. And so if there are more discretionary denials, a different benefit that might accrue to certain funded patent owners is that they find that because there's a discretionary denial, their case gets close to trial, to summary judgment motions, other case dispositive events that drive settlement faster, and they're able to realize the benefits of that in terms of the financial terms that they had negotiated on their funding deal, because there's just a faster resolution. It winds up such that it's to their benefit. And I think that's something that, it's kind of a special benefit that's hidden within a lot of funding structures that I think, and I'm optimistic that people may realize as there's more and more incentive denials.
No, so likewise, I would think that the costs of litigation would go down because you don't have the PTAB, and that helps patent owners too on the back end.
I think so. I mean, one should always budget for what litigation you think might happen. I think that's a follow-on to kind of what Anup was saying, which is that if there's still a real chance of an IPR, the overall funding package should plan to be able to take that IPR through its entirety, assume it gets instituted, maybe even appeal, and be able and have enough money in the budget to be able to handle that appropriately and present the strongest position for the patent owner properly. If you don't need to spend that money in that way, then great. You can spend it other ways, or maybe it's just that the investment necessary winds up being a bit smaller. But I would still recommend that everyone proactively plan for their funding needs as though they will have an IPR that might need to go the distance.
I think what Robin and Anup are saying is absolutely right and brilliant. Like a crutch is never a replacement for quality, and so, but like the complete algorithm of likely success in a patent case is complicated as all hell. And this helps. It just does.
Yeah.
Like one thing that nobody's really talked about here or really anywhere that I've seen is that, part of, I mean, number one, like somebody mentioned that, like, I think Salumeh, it might have been you, that like this will make it cheaper. It's like, which is horribly ironic because like the PTAB was supposed to make this easier, faster, cheaper, but it didn't do any of that. And the other thing I'll say is that stays based on pre-institution filing of IPRs should, if the court has half a brain, which sometimes they do, not opining to your court, but based on likelihood of discretionary denial going up, the percentage of stays should go down. Whether that happens, that's a different issue. But again, what Robin and Anup are saying is 100% right. You have to plan for the worst case scenario. You cannot assume that any court, PTAB, director, whatever, are going to do the right thing according to what your view is. You have to plan for everything. You have to put that all into the algorithm. You have to explain that to the funder. And then, but ultimately, does the likelihood that, especially if you're filing in a jurisdiction where you'll actually get to trial, in a couple of years, as opposed to like places on the West Coast that are measured in eons, that will have an impact, both on the likelihood of winning. Because again, let's be clear here. the PTAB is not about efficiency. That was the plan. The PTAB, and the reason why you're seeing a lot of large companies freak out about the changes that have happened over the past month is not because, oh no, it's not going to be efficient. Oh no, like we can't kill 75% of patents, automatically.
Right.
That's the reason why, they're upset about this. And that wasn't what the PTAB was supposed to be. It was supposed to be efficient, effective, and cheaper, and it's not.
So one of the things, going with what you were saying, Eric, about it would decrease the number of stays. In my mind, it also potentially increases the opportunities in different venues outside of Eastern District and Western District, because you avoid the stay. It might open the door for potentially different defendants or different opportunities, which might help various plaintiffs and technology areas as well.
I think it'll be really fun to see. And again, like as I get older, like I look at life.
We all get older.
As a giant, car accident. Like I'm not rooting for there to be a car accident, but if there's going to be one, I'm going to watch. And I'm also a metrics guy, and I follow. I mean, I get data every day that, especially with the advent of various AI platforms, I can now process in real time and see which courts are doing what. And, it'll be interesting to see, like, even in 3 months, whether, my hypothesis, works out. I hope so. But again, that assumes that courts take into account the actual merits and likelihood of the success of the IPR, as opposed to just being like, oh, I don't have to do a patent case for a while because somebody filed an IPR.
Well, so this kind of, during our prep call, Eric, you mentioned there was a slight dip in funded cases in 2024. And so I wanted to see if you think, based on these different changes or just generally what's going on, is that a trend? Do you expect that to continue in 2025? Or do you guys see a potential increase in 2025 in funded cases?
And, if I had a magic wand and or a crystal ball, no offense, I wouldn't be here with y'all as much as I love you. That said, my thought is that there's been a rush to quality. And that's been because the funding of patent cases is hard, and I think funders and basically the entire process has gotten better. Sorry, my partner is trying to talk. But this is not something that I don't know. Sorry, I lost my train of thought. My partner was trying to do something. But the short of it is that I think it's a larger, what we saw in the dip was that there was some improvement in the process. And now you're seeing better firms, better patents, better people. The fact that Robin and Anup are here, and I'm not just buttering them up. Like, I've known both of them for years, and they are the gold standard. Like, there have been people that have come in, tried to do this. Like, what we all do is not for the faint-hearted. It is not a good hobby to sue Meta in a patent case, because you will die. And so what I've seen is that there's been a rush to quality, and that means that by definition, there's going to be some sort of fall off. I think there's also been, with the judgment preservation insurance drop off. I think sometimes that gets confused into some of the numbers, and that's a very different animal. And I don't see that coming back really anytime soon, at least in the ways that was a bubble in my mind. I think that, I think that litigation funding of patent and trade secret cases is going to continue to grow. It's going to get more sophisticated. I think you'll see more and more, insurance in novel and more creative and better ways. And most importantly, you'll probably see more and more portfolios. And portfolios can mean a whole bunch of different things that we don't have time to get into.
Well, actually, that's a perfect segue to what Robin is going to speak about, which is the portfolios, different types of portfolio funding situations and scenarios. So if Robin, if you can kind of talk about funding for law firms, funding for cases, how that works.
Yeah, I mean, so people talk about portfolio funding. I'll just give a little bit of an overview of what portfolio fundings can look like, and then happy to talk a bit more about certain types. But the idea of portfolio funding is essentially that a passive litigation funder provides capital to finance more than one litigation at a time. Now, who is receiving those funds? It could be a single patent owner, sometimes a business, or even of any size, could be a very large business, could be a smaller business, has multiple patents and multiple potential litigations to bring at the same time. Sometimes a portfolio of cases is held by a law firm that has chosen to take some or maybe full contingent risk on a variety of different litigations on behalf of different clients, and they wish to mitigate some of the risk they're taking and help have some cash consistency to keep the lights on by getting litigation funding on the firm side. Either of those situations can work. From a funder's perspective, what's exciting about doing portfolio litigation funding is that when we get a collection of unrelated risks that we can fund and cross-collateralize them against each other, it gives us an opportunity to mitigate potential losses in view of the winners. The benefit for whoever's taking this portfolio funding is that usually means the funder can offer more attractive financial terms for the funding because they are able to mitigate the potential losses. And given that passive litigation funding is a high risk, high reward investment class, being able to take down that risk a little bit can allow them to mitigate what they have to charge as the reward from the funder side. Practically speaking, I have seen a move towards portfolio funding, I think, because a lot of sophisticated folks who I think are repeat users of funding, perhaps law firms, perhaps certain businesses, have realized that they like the financial profile there better. And also it allows you to really kind of get into a relationship with a funder you know and trust. A passive litigation funder does not have control, should not have, in our cases, does not have control over settlement, strategic decision making, those kinds of key decisions in a case. So it's important to have someone has the capital resources and is going to be there to back you up through the ups and downs that are inevitable in litigation. And when you've got a good relationship like that and you can expand it to a broader portfolio of litigations, that can oftentimes lead to a great opportunity for everybody involved.
I think you can also tell a little bit about the firms and the attorneys behind the case if by talking about a portfolio, because I have been with firms and I have talked with firms that, we won't do a portfolio. Why is that? They're cross collateralized. And I'm like, so you don't think you're going to win, and you just want, you just want the, and there is that. I think it's gotten better over the years, but like the old school contingency cases, I used to love those because everybody on this call knows how to diligence this stuff. There is no perfect world, but I stand by every case I file. We lose some because of crazy reasons that I don't control. Cases take twists and turns. Judges literally die. You can't figure that out. But if somebody isn't willing to bet, they're on it through cross collateralization. If I'm a funder, I'm like, well, then why should I even talk to you?
So is there like a particular, ideal number of cases? Do you guys prefer all like to have a portfolio of all patent cases, or is the preference like, here's some patent, here's some contract, here's some, tort? Like, do you like it diversified in terms of subject matter, targets? I mean, or is there an ideal?
So I think some of this would be a question that could vary from different litigation funders, but I think I'm in the intellectual property group at Fortress, so we are looking for IP cases to be within the portfolio, although other broader commercial litigation funders may have greater appetite for other different types of cases. And I also think that, at least in my experience, 4 cases is sort of the minimum for a portfolio where you really get to see the effects of cross collateralization benefit everyone. And the ideal would be 4 cases of approximately similar size, both in terms of their funding requirements and the upside potential. Some variation is obviously acceptable, but the more independent risks you have in the portfolio, the better they act as mitigants, the lower the pricing that can be offered.
And what are the benefits of these portfolio scenarios for clients? Or is there any difference from a client perspective?
Well, I think from the client perspective, first of all, if it's a portfolio for a client, lower pricing is a benefit for them, huge benefit. And once you have a portfolio set up, many times portfolios are open-ended. Let's say you have 4 cases to start, but you put new cases in over time, even better, right? It simplifies your process. You know what the terms are going to be for funding going forward. On the firm side, I think it saves them a huge amount of time bringing on new clients who need alternative fee arrangements, such as a full contingency fee and maybe cost funding, because it allows them to basically just have a very simple 100% contingency plus cost agreement with their client. The onboarding is very easy in that regard. And because the terms have already been worked out in advance, if the case is an appropriate case to move into the funding portfolio that already exists. So it's, instead of having to do the work of negotiating on every single deal, you can do it once and then streamline going forward.
I think there are a couple of things to keep in mind, though, and I'm being a little bit contrarian about this. One is, adverse selection, right? If I have a portfolio deal with a firm as a funder, how do I know that I've sort of gotten your top cases that you're getting funding for? And this can be an issue for firms that do a mix of pure contingency and funded litigation, where, if you're taking stuff on full contingency, well, are you taking the best cases, for yourself and giving me your second tier ones? And also when they have, sort of multiple funding options, how are you as the funder with a portfolio deal with that firm sort of figuring out that you're not sort of being adversely selected against in sort of the cases they present to you? I think that's one thing that funders should keep in mind. We certainly do. I think as far as the number of cases, I think we look at it a little bit differently in that, we've had firms come to us with 7, 10 case portfolios, kind of a mix of patent and non-patent. And you run into 2 problems. One is that, firms that do a mix of types of litigations, a lot of them don't have sort of elite practice groups across the board. So you need to keep that in mind. They may have a really good patent litigation group, but maybe not a great general commercial litigation group, or vice versa. So that can make, sort of diligencing that a little bit more difficult. And then 2, when you're talking about sort of pure patent litigation portfolios, a lot of firms, there's only so many really great patent litigations out there every single year. To think that, 5 to 10 of them are concentrated in a single firm, that's going to be very rare. So you have to figure out what your risk tolerance is. Do you have enough sort of gems in that portfolio to make it worthwhile? And I think one of the things that Robin said made a lot of sense to me is that, if you're looking at a portfolio of about 4 with the option to add on, that is sort of like an ideal way to do it in my perspective, is that you have a smaller group to start, and then as cases sort of come in and you diligence them one at a time, you can figure out if it's appropriate to add to the portfolio or not.
Got it. Okay. Kind of related to this is, or potentially related to this is the play of insurance when it comes to funding. And they play different roles. Sometimes the insurance is backing the firm. Sometimes it's just backing a funded situation. I just wanted to get your sense of, what does it look like when insurance gets involved, and the impact depending on the timing, if they get involved at the beginning versus later on, and how that impacts both the attorneys as well as the clients or patent owners. Any thoughts on that, Robin or Anup?
Oh, I can comment. I think, the availability of insurance for litigation risks is relatively new, I think, in probably the last 4 years-ish. And so even in that time, it's changed significantly. I think Eric previously alluded to the fact that a very popular product initially was judgment preservation insurance, JPI, which, as you can guess from the name, is an insurance product that is often purchased once a judgment or at least a verdict exists in a case. I think that market has changed significantly, and the availability and expense of that type of insurance has changed a lot. However, there still remains appetite among the insurance markets, especially for portfolios of risks, where I think the same sort of cross-collateralization that I was discussing in terms of how it allows risks to become better diversified for funders also can benefit an insurer. And those insurance products are available to litigants, law firms, or funders, depending on the situation and who is the best situated party to consider whether they need insurance and what insurance to buy. That winds up being pretty fact specific based on situations. But I think that continues to be available for very high quality IP cases.
And do you recommend insurance for patent owners or firms who are seeking funding? Is it a benefit to them to have it?
I think I could speak as broadly as a recommendation. It would depend on particular factors in an individual situation. And I don't know that in any of the funding cases I've worked on, we've ever advised that, insurance be purchased out, and just generally speaking, for, because capital protection, if it's a funded case, the capital is the funder's capital. So they wouldn't really need it in that situation, if you will. So I think each individual should talk to their lawyers. If they're working with the litigation funder, talk to your litigation funder, see if it's something that makes sense for your particular situation. There's times it works, times it really doesn't.
Yeah, plus, there's a lot of different types of insurance plays. There is like insurance across an entire portfolio. There's whip wrap insurance. There's sort of downside risk. Downside risk has been available across a lot of different areas of law for a long time. My view in life is actually to do everything in parallel until it looks like something is stupid, and then freaking stop that. And that I think is a reasonable way to do it. I think study it, get to know really good people in the industry, and then talk to your funders. And Robin's absolutely right. Like, there is no one answer, because there's different types of cases, there's different types of portfolios, and there's different types of risk tolerance across different funders for different portfolios, single patents, and different firms. I mean, I'm blessed to be at a firm that actually, has a strategic mind, most of the time, knock on wood, with things, but there's a wide range of risk tolerances, and none is right, none is wrong. For me, like, there's certainly things that are more convenient, but you guys gotta do your best and realize that there is no perfect.
So we've got like 1 minute left. We have some questions from the audience, from the listeners after that. Just wanted to touch real quickly on the disclosure requirements here, whether it is disclosing just the funding relationship or insurance involved. If we could get someone's quick thoughts on if it should be discoverable, and I mean, the courts are now finding it discoverable, and the relevance of it, if at all. If Scott or Eric, you guys can speak to this briefly.
I think the reality is we're seeing the trend in my view, is probably going to be toward discoverability, and anything like that an adversary perceives as sort of a sore spot or something that they don't want to disclose, they're going to go after for the sake of doing it, right? To enhance pain in some ways. But beyond that, I think the courts will be persuaded that, the argument on the other side for having knowledge of what the arrangement is and things is to facilitate settlement, is what the accused infringer is going to say, because they need to understand how the funding works, who gets paid, and really what it's going to take to settle a case. And anytime you tell a judge that you need information to be able to try to settle the case meaningfully, they want you to settle the case, and so that's going to move the needle toward that as well.
I think there will be. I agree with that. There will be continue to be discussions. There's going to be state laws. There may be eventually a federal law, but I think some states do it right. I haven't delved deeply into the Kansas law, but that seems to split the baby, so that nobody's happy, which means that it's probably a good law. The idea that defendants should be able to get the actual funding agreement, the budget, and these things is just, in my mind, completely unfair, and that kills things. Then you have folks like Louisiana that basically go after what Darrell Issa said was evil, and that was China and rogue states. And it's like, if you want to have additional discovery on rogue states, that's fine, but it is a hot topic, and I don't think anybody knows, but we all need to be alert to it.
Okay. John, I think you're on mute.
All right, there I am. Thanks, Salumeh. Appreciate all of that. Terrific job. And we do have a few questions here from attendees, so I'll get right to it. These are not directed at anyone specifically, so whoever wants to jump in and answer them. First question: how long does it typically take from approaching some funders until signing a funding agreement?
I can start that one quickly. So it depends a little bit on how long it's going to take to diligence your case. So the complexity matters, but I think, Curium, and I think this is pretty typical of a lot of funders, we can probably get you from presenting the case to us to a signed term sheet after we've done our diligence. We don't send term sheets out before we do diligence on the case, like a deep dive on the case, as quick as 4 weeks afterwards. And then from term sheet to signed funding agreement is anywhere from another 4 to 8 weeks. And that really just depends on how much a counterparty feels they need to negotiate the actual funding agreement. I think on the short end, you're really looking at 3 months, 2 to 3 months. But it can take a lot longer as well in certain cases.
Sure, a lot depends on the counterparty there.
It also depends on whether you want a portfolio. The nice thing is that, you have sort of buy one, get 5 free, but you also have to diligence 6 cases or whatever is in the portfolio. So that'll take a little longer.
Okay, next question. Do funders consider the value of a trade secret that was disclosed under MCA, which hasn't yet been exploited by the other party, but is covered by an existing patent and may be commercialized in future iterations? So do funders consider the value of a trade secret disclosed under MCA cover under an existing patent and may be commercialized in the future?
So if there's, I can take the first part, the fact that there's an NDA and somebody has stolen it, that's great. That's bad for the company, but great for me. Because, again, an NDA is now you have, as Scott has mentioned, a breach of contract in addition to a trade secret case. As to the fact that what happens if they haven't actually used it? Then I would, that goes back to the damages argument and what's the harm? If I'm a funder, I probably don't fund a case like that until there's actual provable damages, because, congratulations, you'll probably win because there is a trade, there is a secret, it has some value, but, you get $1. That's what I thought if I understand the question.
Yeah, I think the other thing is that if there was a trade secret at one point, And then it sounds like the question is asking what happens if the actual use of that misappropriated trade secret doesn't happen until after you've sort of applied for a patent and a patent's been publicized or issued. Essentially, that just becomes a patent infringement case with a really good willfulness story, and a really good jury story. So that's how I think I would approach that, at least, is that I wouldn't even look at that as a trade secret case.
Yeah, it's a good point. Remember that a trade secret has to be secret. The minute that you actually disclose it in a patent application that becomes public, ain't a secret and ain't a trade secret anymore.
Okay, and now we're at the top of the hour. One final, very quick question. Just maybe we'll go around the circle. How many cases would constitute a portfolio to you? This is a good question because I've heard different numbers, like 2, 3, 4. Is it just?
Well,
is it
I
just
think I said 4 before, at least 4.
At least 4. So it's not 2.
Look,
2 is not a
sometimes
portfolio.
For the right cases, there could be, 2 or 3 could be a good portfolio to do. But to get the benefit really of cross collateralization, which is the thing that's going to drive the improved economics, about 4 or more.
Okay.
Yeah.
I would say 3 or more, but it's about the same sort of calculus that Robin mentioned. I don't think there's that much difference there.
No, I think that's right. Remember, it's portfolio theory, and think about your stocks. Well, maybe not today, but you have to have diversity. And I don't think that having 3 stocks is really truly diverse. I don't think having 6 is truly diverse, but it is a sliding scale, and it depends on the patents.
We might have to do a separate virtual town hall just on what constitutes a portfolio. What's the exact number? So maybe we'll do a follow up. But we reached the top of the hour, so thank you all for first of all, thank you for attending today's event and for asking questions and participating. We appreciate that. Hope you enjoyed it. I want to thank our moderator, Salumeh Loesch, did a fantastic job today, and our esteemed panelists, Scott Davis, Robin Davis, Anup Misra, Erick Robinson. Thank you all so much. Really detailed answers. We really appreciate it. As a reminder, you're all going to receive a link to a recording of this event within the next day or so. All registrants will receive that, so please stay tuned. We'll also be convening our community the next virtual town hall next month. Details to follow, so please stay tuned for that. And again, if you'd like to become a member of LFJ, you can visit us at our website, www.legalfundingjournal.com. Thank you, everyone. Have a great rest of your day.
I wanted to make one last statement. Just because my managing partner is going to say this, I don't think that any of us speak for our respective firms, companies, or anything else, especially me, because I'm crazy.
Okay. We'll keep that in at the end. Thank you.
Thank you.
Thank you all.